Okay. Good morning, everyone. It is my great pleasure to welcome you to SLTA's June 13 Virtual Title School. My name is Gina Matthews, and I'm the current president of the Southeast Land Title Association, representing title professionals in Mississippi, Alabama, and Georgia. The SLTA Education Committee made the decision at this year's mid-year meeting to hold 3 virtual title schools prior to our annual meeting in September. Each would offer 2 hours of CLE, CE credits approved in all 3 states. This included the June 16th event put on by the Legislative and Governmental Affairs Committee, or chairs of SLTA, today's title school on Alta Forms, and an underwriter panel discussion of current title issues, which was originally scheduled for August, but has now been postponed and will be held in November of 2021. Please stay tuned for the date and time of the underwriter panel title school. We are required by both the bar and the Alabama Department of Insurance to verify your presence during these virtual events. We will post a code for each speaker in the chat located at the bottom of our screen. When you see the code, please make a note of it. You will be asked to give 2 codes, one for the first hour and one for the second hour of the presentation in order to receive your credits. Now, I'm very excited about this title school. It's going to be very informative. And guys, we've got true experts, and this is going to be an excellent panel discussion. But before we start the presentation, I'd like to have a little fun. So Jeremy, Holly, would you please join me?
Hey, good morning, everyone.
Yeah, Jeremy is the Alabama director for SLTA, and he is a master at giving away door prizes. So take it away, Jeremy.
Well, thank you, Gina. Of course, I'm only able to do that due to the generosity of our members. And so we appreciate that so much. And I just want to say that it's great to see you here today. Make sure that you do stay tuned to the website for any other events that we have that are coming up and available, because we would love for you to participate, to stay plugged in. Also, another quick plug, if you're looking to get involved in a committee of any kind, please feel free to reach out to myself or to Gina, but I can help you get connected and get you started on the right path for that. But so what we're going to do is we're going to spin the wheel this morning, and I have some great door prizes to give away. I'm going to move my camera just a little bit here, because what I like to do is go to the wheel, and we have 65 in attendance today on the video with us, and we appreciate each one of you being here with us. And so I'm going to give out I have $50 gift cards that are going to be sent to you directly from those that have donated them. So they will not be coming from me, but I will make sure that you get that. But that's going to come directly from those that have donated them. And so we're going to just start off the first spin. That was a pretty good spin, I have to say. Wow. And I'm the winner, but I'm going to throw that back in. So that was really not planned at all. We're just warming the wheel up, that's all. All right. So Jennifer Collins, congratulations to you. You will receive a $50 gift card from Old Republic National Title with the Alabama office, and that is Miss Gina Matthews. She's our first donor today. So Gina, thank you for that gift. And Jennifer, congratulations to you. And so we will spin that wheel again. Sorry, I'm not doing a great job holding that camera arm. So Miss Shelby Elliott, my neighbor actually here in Coleman, congratulations to you. You have won a $50 gift card from WFG National Title Insurance Company. That's from our friend Tamara Brooks over in Georgia. So I will make sure that Tamara gets that over to you, Shelby, and thank you so much for joining us today. 2 more to go, and then we're going to get started. But this next card will be going to Miss Amanda Cook. So Amanda, congratulations to you. We appreciate you joining us today. And so I have a $50 gift card from Stewart Title Company, the Alabama office, with Mr. Michael Weber. So congratulations to you on that. And then for the last gift for this session is going to go to Philip Holloman. So congratulations to you, Philip. We appreciate you being with us today. And you will be receiving a $50 gift card from First American Title Company, the Alabama office, Mr. Jance Wojnowski. So thank you for that, Jance. And Philip, thank you for joining us. We really appreciate you being here with us today.
Thank you, Jeremy. Oh, I'm sorry.
No, that's okay. I just wanted to say thank you again. And you're welcome to introduce Jance if you like.
Yes. And Jeremy will be back later with the wheel of door prizes. So everybody stay tuned for that. I'm going to now turn the meeting over to Jance Wojnowski. Jance is the current Vice President of SLTA, and he is going to introduce our most excellent speakers. Thank you, Jance.
Yeah, good morning. Thank you, Gina. And thank you to our esteemed speakers, our SLTA members, and to those who may not be a member yet. We appreciate you joining today's event. And thank you, Linda and Marlene, for your help with putting this event together. We're grateful. We have 4 very intelligent, well-spoken experts today regarding the new ALTA forms, and it's my honor and privilege to introduce you to them today. I'll start with Paul Hammond, who is Senior Vice President and Chief Title Counsel for First American Title Insurance Company. He's the Chairman of the American Land Title Association Forms Committee, a member of the ALTA Native American Lands and Title Council Committees, and the immediate past chairman of the California Land Title Association Forms and Practices Committee. Next, we have Dan Buchanan, and he is Vice President and Senior Title Counsel in the Corporate Underwriting Department of First American Title Insurance Company. He represents First American on the ALTA Forms Committee, the Title Council Community, and Native Lands Work Group, and he's also very active in the California Land Title Association. Next, we have Kelly Romeo, who is the Senior Vice President and Chief Information Officer for the American Land Title Association. She has been with ALTA for more than 25 years and serves on the executive and leadership teams. She is the association secretary and works on a number of priorities for ALTA and the title industry. And then last but not least, we have Steve Gold, who is the product director for the American Land Title Association. He has been with ALTA since 2020, and in that time, he is focused on his role as the staff liaison for the ALTA Forms Committee, the ALTA Best Practices Work Group, the NSPS Land Survey Work Group, and in providing management for the ALTA legal publications. So thank you all for joining us today. We look forward to your presentation, and I believe Kelly may have something she wants to add about Steve, so I'll turn it over to Kelly.
Thank you very much, Jance. For those of you who joined the presentation that Paul Hammond and I gave last September, you can imagine with all that content how happy we are to have Dan and Steve with us today. There is a lot of content here, and it's my pleasure just to take a moment to introduce you to my new colleague, Steve Gold. So Steve joined ALTA last fall, as Jance mentioned, as our product director. And in this new role, Steve is really our point person, not just for the ALTA policy forms, but for several other standards and legal publications. Jance touched on a couple of them, but I just want to emphasize, if you have any questions or need more information about the policy forms, ALTA best practices, the ALTA NSPS land survey standard, or our legal and regulatory publications, Steve is the guy to talk to, and he will be delighted to help you. We're so fortunate that Steve joined ALTA at the perfect time to become familiar with the policy forms as our publication date approaches, and our effective date is already in the rearview mirror. Of course, I still remain available to you at any time, so reach out if you have questions or need more information about the forms or any aspect of ALTA or your ALTA experience. And Steve, I wonder if you would just share a little bit about your background. I know you had a full career before joining ALTA, and there are a couple of highlights. Maybe we lost.
Unmute yourself there, Steve.
There we go. I thought we lost him for a second there. There
That
you
would
go.
help. That would help. Thank you, Kelly. I'm thrilled to be at Alton working with the Forms Committee as the staff liaison during what's really an exciting time of rolling out these 2021 forms. Provide you a quick overview of my background. I have a wide variety of experience in working in title, law, various industry committees, and also leading fairly large business and technology development efforts. I'm still a Pennsylvania licensed attorney, but before my career focused more on business and technology. I worked as a corporate bankruptcy attorney and dealt pretty extensively with the federal and state issues of lien positions related to both real and personal property ownership and financing. Among many other activities, I've worked as a title agent in expanding the operations of a Florida title agency to Pennsylvania. So I've had the practical experience of both establishing new title operations and also day-to-day work as a title agent. Spent many years managing complex information, business, and technology projects. So working with the Forms Committee on these 2021 policy has been of great personal interest, and I really enjoy being able to bring my background and skills to the effort. As Kelly said, I arrived at Alta late last year, and it's been a really, really exciting time of preparing to get this new version of the Forms product into the market. I look forward to meeting and working with all of you as we move forward. Please feel free to reach out to me. Any questions that come up, and I hope to see many of you at Alta 1 this fall. At this point, I'd like to hand it over to Paul and Dan for the presentation that we're all excited to be here for. Thank you.
Thanks, Steve. So delighted to have you part of our team working on all of these forms and everything that the LTA Forms Committee does. And it is a lot. We are grateful for the opportunity. We will talk just a little bit in a moment about that process, how all these forms come to be adopted forms, why we do it. This slide gives you a sense of what we'll be covering. Some of this will be repetitious for any of you that attended the presentation that Kelly and I did last September, but obviously that was then. This is now, and we're a lot closer, and a lot has happened actually since September to bring us to this point. So we'll be talking about, why we do what we do in revising policy forms, or in some cases, completely rewriting our contracts. This time around, though, it is a revision, not a complete rewrite. And sort of how we come to do what we do. What's the process? A little bit about that. And then we'll be talking mostly about what we call our base owners and loan policies today, those being the two forms that are issued all across the country in all transaction types, all liability sizes, from the smallest liability our industry insures to the very largest, reaching well into the billions of dollars these days, which for those of us that have been in the industry as long as many of us have, to think that we're doing billion-dollar plus deals is baffling. And yet it's sort of what Dan and I do every day. And at some point, it just becomes a bunch of zeros on a page. The first time you get involved in one with those many zeros, however, it makes you a little nervous and requires a good deal of time, effort, and focus. So we're grateful to be able to do that. And then finally, a little bit about where we are in this process and what you can be doing to get ready. So next slide, Dan, and we'll get going here. Take it away, my friend.
All right, well, thanks, Paul. And hello, everyone. Nice to virtually meet you all. And I'm really thrilled to be able to be part of the presentation this time around. Why do we need to update title insurance policies? It's because things change. There are court decisions that interpret, or in our opinion, misinterpret our policy provisions and cause us to think about how we've worded certain things. Since the 2006 policy forms were adopted, the Dodd-Frank Act was passed. The Consumer Financial Protection Bureau has come into existence. And as you can see illustrated on the map here, remote online notarization and other forms of electronic transaction and electronic commerce has come into existence and has created a little different environment that we need to operate in. We also have some important court decisions, and you'll hear a lot more about McGirt versus Oklahoma and the effect that it has had on our work in reviewing and updating our policy forms. And we've also seen a real focus socially, judicially, legislatively on discriminatory covenants, old historical, racial and other discriminatory covenants in old deeds and covenants that have caused us to take a look at how our policies and forms treat and react to those kinds of things. And there's some examples listed on the screen here about just some of the activity that's taking place around the country that calls that increased attention and focus on the title industry's role in dealing with discriminatory covenants. And let me kick this over to Paul and Kelly and Steve to talk a bit about the process itself.
Thanks, Dan. I've had the honor of working closely with Kelly Romeo for, I don't know, Kelly, 25 years, 24 years, something like that. I first joined the ALTA Forms Committee either in the very, very late 90s or the first year of the 2000s. I've lost track, but Kelly's been with us as the staff liaison ever since then, until her many other duties for ALTA and the industry necessitated that we bring in some additional horsepower in the person of Steve, and we're just delighted to have him here. I feel so badly, Kelly, that Steve joined us last fall, right in the throes of COVID, when instead of our roughly quarterly, but sometimes more frequent meetings face to face, he was stuck dealing with all of us from a virtual perspective. So far, he's gotten the real sense of the hard work we do, but he hasn't had the benefit of the hard play that goes along with that hard work.
That's very true, Paul. I think if you look at this slide on the screen, you may want to insert a couple of little squares in between the three on the top row, and those would be the play hard squares. Generally speaking, the Forms Committee meets in person about 3 times a year, and the process of talking about improvements and revisions to forms is absolutely ongoing. It begins with an idea, usually from one of the members of the Forms Committee. There are more than 30 participants serving on the Forms Committee, representing more than 20 underwriting companies, insurers from around the country. And we invite every ALTA insurer member to have a representative on the committee if they would like to. We really want this to be a consensus-driven process, and the idea is to create ultimately forms and endorsements which will be used and supported in the industry. So it starts with an idea. Maybe the idea is, hey, it's definitely time to update that 2006 form. The world has changed. And then there's a lot of conversation. Many times the full committee will talk about something and then create a subcommittee to do the heavy lifting. But that middle square on the top row is where a lot of work gets done. And when the group has a question, they defer to the Underwriter Section Executive Committee at ALTA for guidance and ultimately recommend standard forms to the ALTA Board of Governors. After adoption, I think you've all seen this in your communications from ALTA. We have a public comment period, and then the Forms Committee reviews any comments that come in. And the announcement of a comment period certainly goes out to the entire ALTA membership, to the land title associations, which share it with their members. And it also goes to a number of industry leaders and customer groups, ACRL and ACMA and Fannie Mae and Freddie Mac and lenders and attorneys and law firms. So there's a large group that has a chance to comment on these forms. Once they're finalized, and sometimes they do loop back. You know, we have, on rare occasion, had enough comments that we loop back and kind of go back to the drawing board a bit, at least on some of the components. And as Dan will talk about with the McGirt case, sometimes something happens that we recognize means we need to go back to the drawing board. And then we do, because the most important thing is to get this right, to have the forms final, posted, effective, published, and make sure that when you all go to the trouble to implement them, that you've got something that is a lasting quality standard. So right now we're in the midst of the yellow and red on this chart. We have an effective date, we have approved forms, and maybe Steve, you'll talk about what the Forms Committee is doing this week to review those final few comments before we publish.
Absolutely. So we've been able to have multiple periods of public comments, which have really led to the Forms Committee going through and making sure, as Kelly said, that we're getting this right. And we've been through a couple phases of that, and we're really in the final stretch of having these forms ready for publication. Forms Committee this week is taking the time to go through these forms and making sure that they're really final and that everyone's in agreement as to what we have. And we hope to roll these out quite soon. So if anybody is interested in receiving those notifications, but does not currently, reach out to me and I'll put you on the distribution list.
Mm-hmm.
So here we have a listing of much of what Kelly and Steve have already talked about. You know, who does all this work? It is truly, and many of you might have heard me say this in September, I mean it to my core, a labor of love that those of us that are honored to be involved in the Forms Committee work hard. If you had asked me back in my youth whether or not I would ever get excited about the kind of focused drafting that we do in the ALTA Forms Committee and spending hours sometimes talking about the placement of commas or the deletion of commas or whether it should be a semicolon or a colon, not to mention the real substance of the words on the page, I would have laughed at you. Because that's about the last thing I thought I'd ever do for my life's work, and yet here I am, and it is so rewarding to have a small part in creating the products that are at the foundation of our industry, are responsible for the revenue in our industry, and that important metric, net profitability to our industry and our individual companies. This process we go through is unlike anything in any other line of insurance, to the best of my knowledge, in that we truly do engage with our customer groups. And as Kelly mentioned, the American College of Mortgage Attorneys, the American College of Real Estate Lawyers, each have title insurance committees and are very active commenting every time we have anything new of substance or a revised form come out of the Forms Committee, along with our trusted and valued business partners at Fannie and Freddie and FHFA and MBA, et cetera. So this just gives you a sense for all of that. And Dan, you can move on. So about a year ago last month, we had achieved a milestone of ALTA board adoption for our base owners and loan policies and the commitment form. And we thought we'd be spending last summer and the fall working to conform all the other ALTA policy forms to the key revisions that we've made to the base policy forms. And then along came July 9th of 2020. And Dan, we celebrated that anniversary last Friday, didn't we?
That's right. We recognized that it had been 1 year since the Supreme Court announced its decision in McGirt. So let me give you a little bit of background. Mr. McGirt was convicted of a very, very serious crime or a collection of crimes in an Oklahoma state court proceeding. But on appeal, McGirt argued that because he was an enrolled member of a Native American tribe and the crime was committed within the Muskogee Creek Indian Reservation, that the state of Oklahoma lacked jurisdiction to prosecute him. And he cited the Federal Major Crimes Act. Under the Federal Major Crimes Act, a serious crime committed by or against a Native American within the boundaries of a reservation must be prosecuted in federal court. Well, the state of Oklahoma, disputed this, not the fact that he was an enrolled member in a tribe, but that there was no Native American reservation, that the Muskogee Creek Reservation, if one had existed, ceased to exist when Oklahoma became a state. The case worked its way up the appellate levels all the way to the United States Supreme Court, and in a closely split decision on July 9th of last year, the court held that that the Muskogee Creek Reservation was established in 1833 by a treaty between the tribe and the United States government, and that there had never been any express congressional action to disestablish the reservation. And the key part of the decision was that a reservation that was created by an agreement, whether it's a treaty or some other compact or executive action between a tribe and the United States government, can only go away through express congressional action. That the fact that everybody in Oklahoma treated these reservations as no longer in existence over more than a century didn't mean that they didn't exist. It just meant that people had not been recognizing them and treating them as such. So that a pretty significant decision. Just with respect to the Muskogee Creek Reservation, it includes about 3 million acres in eastern Oklahoma, including most of the city of Tulsa.
So we woke up at about 6 a.m. Pacific time on July 9th of 2020, read a summary of this decision, recognized that neither our industry nor any of the citizens of Oklahoma, save maybe for its Native American citizens, had thought that there were reservations among the Muskogee Creek and others of its fellow tribes in that area. We also, though, turning this for just a second to our policy forms, realize that we have a choice of law, jurisdiction, and venue clause in our policy forms that first came into being when we adopted the 06 policies And we use in that clause that the law of the jurisdiction where the land is located would govern, right?
Yeah, I fairly eye-opening revelation when we started to really think about it. Some of the initial reaction around the state of Oklahoma and around the country was, well, what does this case have to do with real property? It's a criminal law case. And the majority decision tried to frame it as a criminal law case, but it was very clear that what this decision said was, if a reservation had been created, a reservation is still there unless Congress has done something to make it go away. And we recognized that meant that these historical reservations with their historical treaty boundaries might exist across the entire country. The decision by the U.S. Supreme Court has broad-reaching implications. And one of the things, the slide here mentions the challenge of new regulatory authority. And so what do we mean by that? We recognize that there are areas around the country where reservations are known to exist. They have existed for a century or more, and we are in some cases used to dealing with property within the boundaries of those reservations. But that practice of dealing with property within the boundaries of a reservation is something that has developed over years, over decades, over more than a century of understanding what the position of the tribe is with respect to regulatory authority, what the position of state and local governments are, and how those work together. And what we recognized existed now in Oklahoma and is a governmental jurisdictional circumstance that nobody had thought through, that this was a new situation and nobody was really clear on what that actually will mean in practice. As I said, the decision's not an issue of criminal law jurisdiction, although that was the focus. The decision, at least from our perspective, was really the recognition of jurisdictional boundaries of reservations and the authority of Native American tribes. The Muskogee Creek Reservation exists for all purposes. And while it doesn't necessarily affect the ownership of land within the reservation, it is clear that the tribal government is the governing authority within the boundaries of a reservation, subject to various established laws and regulations. So when we look at jurisdiction within the boundaries of a reservation, there's a couple of factors that come into play. The nature of the ownership of land. You have land that is held in trust by the United States government for the benefit of a tribe. Tribes sometimes own land not in trust, but typically tribally owned land within the boundaries of a reservation is held in trust by the United States government. We consider that trust land. There's also restricted land, and that applies to land that has been allocated out to various Native Americans, individuals or families that are held in trust or restricted status by the United States government for the benefit of those Native Americans. And then there's fee ownership. Over years, land within reservations were allocated out to individual Native Americans, and over time they removed those properties from restricted ownership. They sold them to non-Indians. They mortgaged them and lost them in foreclosure actions. And so there is a substantial amount of land within a lot of Native American reservations that's held in fee or unrestricted fee status, sometimes by Native Americans, sometimes by non-Indians. And that can affect how jurisdictional issues are applied within the boundaries of a reservation. There's also the question of tribal membership. A tribe obviously has more jurisdictional authority over its members than it does over non-members. And then there's the important boundaries that are established by a case called Montana versus United States. And this case is really important to understand because it plays into what Paul was just mentioning about how contracts and including our policies treat the concept of jurisdiction. And what the Montana case held was that a tribe does not have jurisdictional authority over non-Indians within the boundaries of a reservation on fee land, except for two exceptions. One exception is a consent exception. If the non-Indian has consented to the jurisdiction of the tribe will have jurisdiction. And that consent can be manifested by contractual provisions or simply by conduct that evidences their understanding that they are or should be subject to the jurisdiction of a tribe. The second exception is if the conduct of the non-Indian threatens the health or safety or welfare of the tribe or tribal members or the integrity of the tribal government. And it's really that first exception, that consent exception, that caused us quite a bit of alarm, because as Paul mentioned, we looked at the 2006 policies, and what do they say about jurisdiction? The choice of law and forum provisions in those policies say that the policy should be interpreted by the law of the jurisdiction where the land is located. The law of the jurisdiction where the land is located. If the land is located within the boundaries of a Native American reservation, what is the court going to do with that? And it became very clear to us that it would not take much of a stretch for a court to say the jurisdiction is tribal jurisdiction. You are subject to the laws of the tribe and the court system of a tribe.
And Dan, generally speaking, that is not our intention, and that is not the law to which we underwrite, and that forms the real property foundation for so much of our covered risks in our policies, right?
Yeah.
So, we chose that term jurisdiction back at the time of the 06 policy forms, because we thought it was a generic way of effectively referring to state law. One of the challenges that we have when we draft these contracts is our knowledge that they're going to be used nationwide. And so we sometimes make balanced decisions in the words we select in an effort to try to be generic enough so that they'll work across the entire country. the result of the McGirt case, or that a McGirt case might find its way to the United States Supreme Court, was about the furthest thing from our thought process back then. And as we went through, beginning in roughly 2016, this process of revising the 06 policy forms, right on through the board's adoption in June of 2020 of the base loan and owner's policy and commitment form, we kept that word jurisdiction in there because we didn't realize at the time what the law of unintended consequences would come up as a result of McGirt.
That's right. And Paul, I think we lost your video and your sound is a bit garbled. You might want to step a little bit closer to your microphone. Having a little bit of trouble hearing you sometimes.
I apologize. Is that any better?
Maybe a little.
Paul, this is Kelly. It's still a little bit garbled for me, so maybe it would be good to keep the video off for a little bit. It could be a bandwidth issue. And if you're connected to a company VPN or any other applications on your laptop, it might be good to disconnect, but we'll keep rolling.
So well, let's talk. So it's one of the things that we also realized is how broad this application could be. Those of you familiar with Oklahoma may have heard the term 5 tribes, or they used to call them the 5 civilized tribes, which included the Muskogee Creek, the Cherokee, the Chickasaw, Choctaw, and Seminole nations. There's also the Osage, another prominent tribe within the state of Oklahoma, all under the same circumstances as the Muskogee Creek. And true to our expectations, there have been appellate level decisions, not Supreme Court decisions, but appellate level decisions already issued with respect to all of these tribes that that acknowledge that the boundaries of those reservations still exist. The reservations still exist. These constitute essentially the entire eastern half of Oklahoma. Is all now within recognized reservation boundaries in an area that a little over a year ago nobody thought actually existed. There have also been other cases around the country. Not too long after the McGirt decision, there was a decision in a federal court of appeal for the Oneida Nation in the village of Hobart in the state of Wisconsin, establishing its reservation. The Yakima Nation in the state of Washington, the Ninth Circuit just recently ruled. It did not expressly base its decision on McGirt, but it did establish a much larger reservation boundary than originally anticipated. There are cases pending in Michigan and Minnesota, and we anticipate more around the country. Anywhere that a reservation existed, historically, there is the possibility that it has either been diminished, reduced in size, or disestablished, at least treated that way historically, but not really, and those may be reestablished or re-recognized. We also, this was also eye-opening because while we don't frequently insure within the boundaries of a reservation, there are areas around the country where we do historically insure property within the boundaries of a reservation. And I'm not sure it ever really occurred to the industry that our choice of law and forum provision could mean that we were subjecting the interpretation of our policy and our claims process to tribal law and tribal courts. So what did we do? The Forms Committee met shortly after the decision was issued, and one of the first things the Forms Committee decided to do was to create a subcommittee. As Paul mentioned earlier, or Kelly, I think, mentioned a lot of the hard work of the Forms Committee is done at the subcommittee level. We created an operative law subcommittee, and I had the privilege of chairing that subcommittee. We called it operative law because we were focused on the issue of what law should apply to our policy forms. And the first task was we needed to manage the risk under our 2006 policies. We recognized that those policies will be in use for some time, notwithstanding the impending, adoption and publication of the 2021 policy forms. There is going to be a transition period, and we knew that we had to figure out how to deal with the way our 2006 policies are currently drafted. And the result is the ALTA 47 series of endorsements. And we'll talk about those in just a minute. We also recognized that we needed to address the pending 2021 policy forms and other endorsements that are impacted by how law is applied and what happens when you're within the boundaries of a Native American reservation. So we'll move through this fairly quickly, but we'll take a little time to talk about the ALTA 47 endorsement and what it does. What we did with the 47 endorsement is we created a couple of new defined terms. We revised the choice of law and forum provision, and we added exclusions. And we did that in a series of endorsements. Each endorsement is specifically designed to work with a particular policy. The ALTA 47, for example, works with the 2006 owner policy. The 47.1 is designed to work with the 2006 loan policy. The 47.3 or the 47.2 works with the homeowners policy, and so on. There are addendums that work with the short form policies that don't use endorsements. They're modified by attaching an addendum. And the reason we did a separate endorsement for each of the policies is because when we define the new terms, revised the choice of law and forum provision, and added exclusions, we did that by specifically inserting them into the conditions of the policy or the exclusions with the right numbering system. And so that meant each endorsement needed to be unique. The terms that we elected to define are state. The existing policy forms use the term state with a lowercase. And so we added a definition of state in both its capitalized initial cap and lowercase definition. And we defined that the state as the state or commonwealth within whose exterior boundaries the land is located. But we also added the District of Columbia, Puerto Rico, Virgin Islands, and Guam. Why did we do that? Well, we did that to specifically talk about the states to the exclusion of tribes and reservations. We also added a definition of tribe because for the purposes of our exclusions, we end up using that terminology. And then we addressed the existing choice of law and forum provision. And we did that by deleting the reference to jurisdiction where the land is located and used instead the term where the state where the land is located. So you'll see the capitalized term state throughout the choice of law provision. And in the choice of forum provision, we specified that any action must be filed only in a state or federal court having jurisdiction, again, with the intent of excluding the unintentional application of tribal law or subjecting the policy to the tribal court systems. And then finally, we added exclusions to the policy. These exclusions are added in brackets. As you may know, in our policy forms, bracketed provisions indicate that they are optional, that they may be included or deleted as deemed appropriate by the issuing underwriter. And so each of these endorsement forms contain an exclusion for defects, liens, encumbrances, adverse claims for matters that don't appear in the public record but would be disclosed by tribal records, records maintained by or on behalf of a tribe or its members. The loan policy forms also include an exclusion for any claim of invalidity, unenforceability, or lack of priority resulting from the application of tribal law because an insured mortgage fails to specify state law as the governing law. Why is that important? It's important because we discovered that the uniform instruments used by Fannie, Freddie, most institutional lenders all had the same flaw, if you will, that our policies did, in that they select the law of the jurisdiction where the land is located as their choice of law. What does that mean? That means that if a mortgage is going to be foreclosed in the Muskogee Creek Reservation, there is an argument that the foreclosure must be conducted in accordance with tribal law. Not every tribe has a foreclosure code, but a lot of them do. And the Muskogee Creek Code, for example, requires judicial foreclosure, even though most foreclosures, well, Oklahoma recognizes both non-judicial and judicial foreclosures, but this would force a judicial foreclosure in tribal court. And then at the conclusion of the foreclosure, according to the Muskogee Creek Code, the lender can only dispose of the property by offering it for sale to the tribe or a member of the tribe. Obviously not what the lender would intend. So the exclusion is added to, if nothing else, encourage lenders to modify their loan documents. Fannie and Freddie have both issued publications specific for Oklahoma, allowing their originators to make that change, and also recognize that this is going to be, an issue in other places around the country. So these are bracketed. They can be deleted if the underwriter has determined that either there are no tribal records that need to be excluded, or that we have access to any, and they can be reviewed and specific exceptions can be taken, or that the mortgage does contain an appropriate choice of law provision, and on that basis can be deleted. Which brings us to a break time, and I will turn this over now to Gina and Jeremy for announcements and door prizes before we get back into the program.
Okay, our break is going to be for 10 minutes. So if you want to see who gets the door prizes, you can stick around, or this would be a good time to get a cup of coffee or whatever. And then I will make an announcement and we'll get back to it. Jeremy, are you ready for some door prizes?
I am ready. Thank you so much, Gina. And thank you again to all of our speakers this morning. That's a lot of background to take in, but thank you so much for doing the work and getting that information out to us. We really appreciate that. And so with that, let's spin that wheel. Get the camera moved. best way to do it so that you can see what's going on. Right, so Joel Weatherford, congratulations to you. You will be receiving a $50 gift card from North American Title Insurance Company. That's with our friend Karen Bates, and we will get her your information so she can get that sent out to you. But Joel, thank you for being with us today. We really appreciate that. And thank you, Karen, for that wonderful gift. We next have a card going to Amy Von Seebach. Congratulations to you. You will be receiving a $50 Old Republic National Title gift card from our Georgia office with Miss Nancy Bowman. Nancy, we appreciate you always supporting us. Thank you for that so much. And again, Amy, that will come directly to you. Couple of more prizes so that you'll have some time to get that coffee that you might need. Stephen Blackwell, congratulations to you, Stephen. We have a $50 gift card from Old Republic National Title from our Mississippi office from our board member there, Terry Will. Terry is a great guy and we appreciate his support as always. And Stephen, we appreciate you and look forward to seeing you soon. And then the last door prize for this session, and then we'll have a few more at our next break. This will go to Bart Crawford. Congratulations, Bart. We have a $50 Stewart Title Company gift card from the Alabama office with Mr. Michael Weber. So we'll get Michael to get that over to you, Bart. And thank you for being with us today. We appreciate you. And Michael, thank you so much for your support of SLTA. So that is all the door prizes that we have for this session. Please make sure that you stay with us for the next session, and I'll see you soon. Gina?
Thank you, Jeremy. Great job. Everyone, we're not going to have another break. We will have more door prizes at the end after the presentation has concluded. I'd like to join Jeremy in thanking the speakers so far. I'm hopeful that we get our technical issues worked out so that Dan will join us after the break. Dan was our presenter before, and he's one of the true experts on this topic and on the forums, and I'm looking forward to the rest of the presentation. I'd like to make one quick announcement. SLTA has a 1-hour virtual ethics course scheduled on September the 6th, which has been approved for CLE and CE credits in all 3 states. And this was announced at the mid-year meeting, but for those of you who attended our mid-year meeting in April, this course is free. So I look forward to seeing you all there. And with that, the announcements are over and we can get started back if our speakers are ready. Dan, you good to go?
I am ready. If Paul's here, I will turn it over to him to kick off this section.
I think I saw Paul had rejoined, but it may be that we need Linda to make him a co-host again so that he can unmute. Hang on.
Working on that now.
Okay, thank you.
Okay.
Because I see him in the list. Paul.
Okay, I will. And while we're waiting for Paul to get on, we'll take this next hour and we'll look at the 2021 policy forms. We'll focus on what we call our base policies, the owner policy and loan policy, and towards the end we'll talk a little bit about additional policy forms, revised endorsements, and catch up on those items.
I've made him a co-host so that he should be.
All right.
There he is.
Okay.
Oh, great.
Well,
Welcome back.
thank you. Can y'all hear me?
Yes.
Great. Thanks so much, Dan. Thank you, especially for the seamless way you covered for my technology challenges. I think it's because we work so closely, we finish each other's sentences, and you're used to seeing me have technology challenges. Before we get into the specifics of the 2021 policy forms, and by way of a little transition from the slides that you were last showing before the break, specific to the exclusions that we put into the 47 series endorsements, and that first one that talked about excluding defects, liens, encumbrances, and other matters that might be disclosed in records maintained by the tribe or on behalf of the tribe or a tribal member. I thought we had a defined term public records in our policies, and why is it that doesn't cover it? So in other words, why is it that that exclusion might be an important exclusion if we're dealing with land within the boundaries of a Native American reservation that has some kind of records?
Well, that's a great question. A lot of people think that because the policy defines the term public records and that somehow our policies only cover what is in the public records. And it's important to recognize that our covered risks, very few of them actually are limited to coverage for matters appearing in the public record, and generally those are the specific covered risks that deal with governmental enforcement powers and environmental issues. The term public, unless we take an exception in a policy for matters not appearing in the public record, and that exception is frequently deleted in any kind of an extended coverage or broadly cover, broad coverage policy. Unless we are excluding matters not appearing in the public record, we're providing our covered risk deal with defects, liens, or encumbrances, regardless of whether or not they appear in the public record. And so it's important to recognize that if you are within the boundaries of a reservation and you are not taking an exception for matters not appearing in the public record, you're giving coverage for matters that could be contained within the records of a tribe or any other organization. It's also important to look at the definition of public records, especially in the 06 policy. And while it refers to state, because state is not a defined term in the 06 policy, it is possible that a court could expand the definition of public records to mean the records maintained by a tribe. Just as courts around the country in some instances have expanded our definition of public records, notwithstanding what the policy actually says, to include records maintained in other filing systems that are not related to constructive notice about matters affecting real estate.
Great answer. Thank you, Dan. And those covered risks you mentioned in the 06 policy that are specifically limited in their scope by tying to the defined term public records are covered risks 5, 6, 7, and 8. And we'll talk about how those look as we transition now into the 2021 policies. We're going to divide this up as we typically do when we train on our title insurance policies, and for that matter, as we draft them into various sections. But beginning with new and revised defined terms. This is an area like all contracts that take the time to define certain terms and then use those terms as the contract proceeds. I find it very helpful to actually begin my review of any contract with the definition of terms section. Because once I know that there is such a section, once I know that certain terms have been defined, and then usually those terms will be initial capped throughout the body of the contract. If the provision intends to use the term as defined, it allows a reading of the rest of the contract with more understanding, informed by what the definition actually says. So would you like to move the screen now, Dan? If you're able, there you go. So we're not going to spend time, except in a few instances where relevant to some future slides, getting into the actual language of the defined term, but I wanted to highlight for you the new defined terms in the 2021 policies that you don't find in the 06 policies. Affiliate, consumer protection law, discriminatory covenant, enforcement notice, government mortgage agency or instrumentality, obligor, PACA, passive trust, and yes, our new defined terms state. Then we have some revised defined terms. So these are existing defined terms in the 06 policy form, but we have made some revisions to them in the 2021 policy. So it'll be important to understand how we've tweaked these defined terms of entity, indebtedness, insured, land, and yes, public records. So now let's get into the covered risks. Dan, you want to take this one?
Sure. Covered risk 2 and covered risk 9 in the loan policy are broad. They're broad coverage provisions. Really, it's defined by the very first sentence. Any defect in or lien or encumbrance on the title. Period. That's the coverage. The rest of this is examples of what would fall within the coverage of a defect in or lien or encumbrance on the title. But what was important here is that we wanted, for the benefit of our customers, to specifically address the expanded use of remote online notarization. So you'll see highlighted the phrase remote online notarization in sub-item A3. You'll also see the highlighted phrase repudiation of an electronic signature. We wanted to specifically acknowledge that the repudiation by someone of a signature, an electronic signature, would be a defect on the title. We also, an issue that wasn't clear from the 06 policy language that we wanted to make clear we intended to be covered is the boundary line overlap that you'll see in 2C.
Thank you, Dan. And now we get to covered risks 5, 6, and 7 in the 2021 policies. Again, what is within the scope now in the 2021 context of covered risks 5, 6, and 7 would be the basic subject matter that today in the 06 policies are found in covered risks 5, 6, 7, and 8. 7B in the 2021 policies is really covered risk 8 in the 06 policy forms, and we have a new covered risk 8 in the 2021 policies that we'll speak to in a moment. So a little history on this. Going all the way back to the year 1984, when the 1970 foreign policy was amended. It was amended in only one respect, in exclusions 1A, 1B, and exclusion 2, to add a little phrase that reads, except to the extent that, and also to make express reference for the first time to environmental protection laws, ordinances, and governmental regulations. That approach was mirrored in 1987 when the ALTA adopted the 87 policy forms. So that again, if you look at those policies, you'll see a little except to the extent that phrase in the exclusion section of the policy. Then we moved to 1990 when the 87 policy was amended in one respect to add for the first time to the exclusions section of the policy an exclusion for fraudulent or preferential transfer challenges. In 92, that exclusion was revised, morphing the form into what became known as the 92 policy. Again, however, the covered risk section of those policies did not have these covered risks. Instead, they had this little except to the extent that phrase in the exclusion. Well, that takes us back to math class. I learned in my math class that a double negative equals a positive. So I think it's fair to say that the ALTA Forms Committee at the time, in inserting those little except to the extent that phrases in the exclusions section of the policy, creating a double negative, thought that it was adding some coverage in the context of otherwise an exclusionary clause by, if you will, accepting to the exclusion. Courts, however, between the 87 policy and the 06 policy told us that that isn't where you find coverage. You do not find coverage in an insurance contract anywhere in the contract except in the covered risk section. So beginning with 06, we said we're going to need to move what was intended as coverage built into an exclusion into the covered risk section of the policy. And for the first time, we had covered risks 5, 6, 7, and 8 that effectively are providing some limited coverage as to violations or enforcement actions of governmental laws, ordinances, regulations, or exercises of governmental police power, or exercises of the power of eminent domain, with the limitation being that a notice of enforcement or a notice of violation is recorded in the public records at date of policy. There is your scope limiting clause referring to the public records. We learned between 06 and our work on the 2021 policies that maybe just referring to a quote notice end quote recorded in the public records wasn't sufficiently specific as to signal to our industry what kinds of things they need to be looking for in their search and exam. And so one of the significant improvements we believe we've made to add some clarity to the our contracts in the 2021 policy forms is with a new defined term, enforcement notice. You see it on the screen. Tying it as we do to a document recorded in the public records, but being a notice that is issued by a governmental agency, identifying a violation or enforcement, or is issued by a holder of a power of eminent domain, or a governmental agency that identifies the exercise of a governmental power, or asserts the right to enforce a PACA PASA trust. And we'll get into what the heck a PACA PASA trust is in just a moment. So that's a significant change, one that we think will be very, very beneficial to our industry in doing a more effective job signaling the type of notice that, if recorded in the land records, we intend to become an exception to coverage in Schedule B. If we miss it or otherwise fail to take the exception, then the covered risk provides coverage against loss by reason of that enforcement or that violation. Now we turn to covered risk 10. Dan, you want to take this one?
Sure, I'll talk about this one. In the loan policy, there is coverage in covered risk 10 for the lack of priority of the insured mortgage over any other lien or encumbrance. What we have done in the 2021 policy is we have specified what elements of the indebtedness we are giving priority coverage with respect to. And in the 06 policy, this was not spelled out in this kind of detail. We thought it would be beneficial to be very clear about what a lender can expect to have priority coverage for, particularly in the context of future advances, advances that are made after, after the date of policy. And so we are specifying now that we're giving coverage for the principal dispersed at the date of policy, the interest that is earned on the obligation that's secured, expenses of foreclosure, that's a future expense or advance by a lender that we are willing to ensure has priority. Insurance premiums if they have to advance insurance premiums for the protection of the property, and payment of real estate taxes and the regular periodic assessments by a homeowner association are also the types of advances that a lender would typically make. What don't you see here? You don't see future advances of principal increasing the amount of the loan. You don't see some types of what a lender might consider protective advances, or money paid for substantial repairs or rehabilitation of a property, outlays that that might take place in the future. Because of the way state laws vary, in our base policy, we want to be careful about what we give priority coverage for in terms of future advances. Not that we can't provide coverage for that, but that is done through an endorsement, typically the Alta 14 series. If a lender intends or wants to have assurance that certain types of future advances are going to have priority coverage, we need the ability to underwrite that based on the nature of those advances, law of the jurisdiction, and so that kind of coverage is not part of the base policy. It's available by endorsement.
So Dan, some members of our audience today might be looking at that and thinking, well, boy, that's a major pullback in coverage. Now I got to worry about getting this endorsement, and what's the big deal? Because they might be well aware that the law of their state fully supports the proposition that future advances enjoy the same priority no matter when they are advanced as established at the time of loan origination and that first recording of the mortgage instrument in the land records. Well, they might be very correct in that understanding, but you made the point that this is another example of how when we're drafting contracts for use across the entire country, we sometimes have to be a little more limiting in the base policy product than what any of us might be in any given state where the law is fully supportive of absolute priority established at recording for all advances of any kind whenever they are made. Some states refer to that as multiple indebtedness mortgages. Some states refer to that as all monies mortgages. And there are certainly other terminologies used in other states. It may be that to achieve that, that priority benefit requires some specific language in the mortgage document, sometimes in the actual heading of the document, bolded with a certain typeface, but maybe not in your jurisdiction. So to your point, again, we wanted to highlight the need for an endorsement to expand the priority coverage. And then obviously underwriters will be underwriting that to the content of the mortgage documents as well as the law of their jurisdiction. And in most instances, we'll find it very supportable to issue that sort of an endorsement so as to give the lender the full priority coverage they really need. It's just that in other jurisdictions, it may not be so easy. So that's the idea there. And if you look at the 06 policies, although the covered risk itself would make it appear as if there's a very broad priority coverage given without any limitation on when advances are made, you can't forget about the fact that the post-policy exclusion 3D, overlays all of the covered risks as do all the other exclusions. And so even today with an 06 policy form, if you're dealing in a future advance mortgage context outside the context of a construction loan, because that's dealt with in covered risk 11, you need to be thinking about this and obtaining these sorts of endorsements, which again, where the law and the mortgage documents support the giving of that priority coverage, generally are not going to be difficult to obtain. We just don't want lenders and their counsel to forget about the need for those endorsements. So sorry to drone on about that a little bit, but it's an important dynamic, I think, of the 2021 policies and explain some of the rationale there.
Yeah, I completely agree. Let's move on now to the exclusions.
Let's do it. And since I just talked for a while, nobody wants to hear anything more from me for a few minutes. How about you go?
All right. Well, exclusion 1, which deals with laws, ordinances, governmental police power. We've added the phrase in 1B to forfeiture and regulatory and national security power. This is a clarification, we believe, of what has always been meant by the exclusion for governmental police power. But we thought that that police power itself might be too narrowly interpreted by a court, and we wanted to make clear that governmental, by that phrase, we mean governmental forfeiture ability, governmental regulatory issues, and we wanted to add national security powers. There are a number of laws that have been enacted that affect the ability of the government to regulate matters in the name of national security, and we thought it was important to be clear that we expect the governmental police power exclusion to include those types of enforcement or regulatory matters.
And as with a number of other exclusions, Dan, if you just go back a moment again, it's important to catch the last sentence. Again, cross-referencing back to the covered risks, specifically in this context, covered risks 6 and 7, or excuse me, 5 and 6, making the point that this exclusion does not modify or limit the coverage we intend under those specified covered risks. So again, getting back to if there is a notice of enforcement recorded in the public records by a governmental body identifying a violation of any sort of governmental regulation or law or an enforcement action pertaining to that. And just one type of enforcement notice that you might run across would be alias pendens, just as an example. So if there's a forfeiture action and the government does what, in my humble opinion, it should do, but it doesn't always, and records alias pendens against the title of property that is the subject of that forfeiture action, surely we should pick that up in our search, take exception to it in Schedule B, and if we miss it for some reason, or it was misindexed and we don't take the exception, then there would be coverage because it exists in the public records. So just wanted to make that point, and now we can go to exclusion 3E. Exclusion 3E has often been referred to as the failure to pay value exclusion. Over the years since the 06 policies, we've come to understand that this exclusion was frankly misunderstood and often misapplied. It said failure to pay value for the estate or interest, the insured estate or interest, or for the lien of the insured mortgage. We did not ever intend this exclusion and the reference to value to be the same as reasonably equivalent value, words that come out of certain laws in the bankruptcy code and state fraudulent transfer laws. We didn't intend it as being fair market value. We really intended it as the kind of value that is referred to in our bona fide purchaser for value statutes and case law. Because if an insured fails to pay at least that amount of value to qualify themselves as a bona fide purchaser for value or a bona fide encumbrancer for value, their insurer, won't have a defense to a claim against them by someone, for example, who did not have a recorded interest in the title before the insured's interest became recorded against the title. And so it's really that simple. And we think we've made a heck of a clarification here in the new language for this exclusion that's in the 2021 policies, and should be reason enough, we think, that people will prefer these forms. Then we get into exclusions 6 of the loan, 4 of the owners, our creditors' rights exclusions. Again, I mentioned first added in 1990, narrowed in 1992, and carried forth in our policies ever since that time. Really an area of law that, in my humble opinion, the industry has no business in insuring in, at least not as it pertains to fraudulent or preferential transfer risk arising out of the transaction that is the subject of the insurance, the transaction that creates the insured interest. You all know, but we didn't highlight them when talking about the covered risk section, that we have a covered risk that addresses these types of issues, but what we call the back chain creditors' rights coverage, because it's intended to deal with fraudulent or preferential transfer challenges that arise out of transactions in the chain of title preceding the insured transaction. There are defenses that the industry would have to those kinds of challenges that the industry would not have in the context of fraudulent or preferential transfer challenges arising out of the instant insured transaction. So that's the reason for this exclusion. That's the scope of this exclusion. And really, the tweaks you see highlighted there are the changes for the 2021 forms. About 29 states, I think, have enacted as their state fraudulent transfer law now the Uniform Votable Transactions Act, replacing whatever that state's predecessor statute was, probably one or the other of the Uniform Fraudulent Conveyance Act or the Uniform Fraudulent Transfers Act. So now that we have these statutes evolving across the country, the Uniform Votable Transactions Act, we thought it important to make reference to those new laws. Again, an example of how when laws change, we sometimes find the need to update our policies. And then under the preferential transfer arena there, adding to the extent the insured mortgage or in the owners, to the extent the instrument transferring the title is not made as a contemporaneous exchange for new value. So effectively, those words come out right out of section 547 of the Bankruptcy Code, preferential transfer section of the Bankruptcy Code, and is there to make clear that we are not intending coverage against preferential transfer risk in any instance where the transfer is not made as an exchange for contemporaneous new value. Next slide. The PACA trust. So do you want this one or you want me to take it, Dan?
Oh, I'll talk about this one. For years, there has been federal law, and you can see the code references there at the bottom of the slide for PACA and for PASA. What does that mean? PACA is the Perishable Agricultural Commodities Act, and PASA is the Packers and Stockyards Act. These are federal laws that provide protection for people that are producing items, agricultural and food items that once delivered can't effectively be repossessed because they spoil. They go bad. If you give them to somebody and they don't pay you for them, what's your recourse? And so these federal regulations have existed for decades that provide protection for these suppliers by creating a trust arrangement. It's kind of like a silent lien, although functionally it's a little different. It creates a trust so that the proceeds of these products are held in trust by the distributor or recipient for the benefit of the creditors, the suppliers of these products. And as I said, these laws have existed for decades. And for decades, the title industry was largely unfamiliar with these until we had some expensive examples of how these might affect title. And companies started experiencing some claims because effectively, if you take the proceeds of these agricultural products and don't pay the suppliers, and you take that money and you use it to buy or make payments on real estate, the trust can encompass the title to the land. And what does that mean? That means the person who owns the property of record may legally only hold it as a trustee for the benefit of the suppliers. And the industry suffered some rather sizable claims on these PACA issues. And so any of you that deal with agricultural transactions or deal with commercial transactions involving grocery stores, mini markets, residential facilities that provide food service like nursing homes, some schools, hotels that have restaurants, all of these various types of industries are subject to these PACA and PASA trusts to the extent that suppliers haven't been paid. And so the industry started having to grapple with these by putting in Schedule B exceptions and then trying to figure out if we could learn enough about the circumstances to figure out how to underwrite and delete that exception. A lot of confusion with customers that were not used to seeing these things. And much like creditors' rights that we just talked about, this is virtually impossible for us to adequately underwrite. And so a decision was made to now include an exclusion for Pakapasa trust claims in both the owner and loan policies, but with a important counterpart covered risk 8, a new covered risk in the policies that do provide coverage if there is an enforcement notice in the public record. And so that's why the definition of enforcement notice that you'll recall from an earlier slide also referred to a notice of enforcement of a Pakapasa trust. So if there is an enforcement notice of record, covered risk 8 now it will provide coverage against claims arising from enforcement of a Pakapasa trust. But otherwise, these claims are now excluded because they are, in effect, essentially a creditor's rights kind of issue that we have discovered we can't adequately, or in many cases, can't adequately underwrite, and really shouldn't be providing coverage for. Do you want to add anything to that?
Sure, Dan. And just as is true of fraudulent and preferential transfer risk, Pakapasa trust risk is a credit risk. And some might say that to insure against that risk isn't even title insurance, it's credit insurance or credit risk insurance. And in any case, beyond the scope of a single premium, long tail on coverage, strict liability kind of policy of insurance, such as is title insurance. So hence the addition of that new exclusion. And yet another new exclusion that hopefully won't be completely new to everyone, because as with Pakapasa trust risk today under the 06 policies, you may have occasionally seen Schedule B exceptions that effectively carve out this coverage in any case where the legal description that's come down through the chain of title contains references to acreage or square footage or what have you. It's never been the intention of our policies of title insurance that we insure against that risk. There's another approach one can take when a legal description in the chain of title or in the existing deal documents contain those references. Nobody says we have to use that same legal description in our policy. So in other words, for purposes of our title insurance policy, one can use the legal description and simply cut out the references to square footage, area, acreage, etc. So that was the response that various underwriters would often have when they would see those kinds of references in their legal descriptions. However, that's sometimes bothersome to our customer groups because they like to see the identical legal description in their title insurance policy as appears in their conveyance instrument or their mortgage instrument, and as has appeared, in the chain of title leading up to the instant transaction. So where we've maintained that reference in the legal description of the policy, then under the 06 forms, we would often take a Schedule B exception that effectively reads very similar to the way this exclusion reads. Because it's never been the intention to provide coverage against this risk, adding efficiency to our process, as is true of the Pakapasa exclusion we just talked about, now by building in this exclusion, eliminates the need to take Schedule B exceptions, eliminates the need to worry about cutting this out of the legal description that we use in our policies as distinct from the legal description that's used in the conveying instruments or the mortgage instruments. So that's new exclusion 9 of the loan and 7 of the owners. Now we get into the schedules, Dan.
Yeah, let's talk about Schedule A. In the 2021 policy at the top of Schedule A, you will now see transaction identification data. And this was added basically for 2 reasons. One is customer convenience, to put the critical information, the reference information about the transaction right at the top. And it also builds in the ALTA registry ID number in order to help facilitate a customer's use of that registry ID to confirm the agent's status with the particular underwriter. This is intended to just create an appropriate spot on a policy form for aggregating this kind of information for both the users, the company's convenience as well as the customer's convenience. And you'll note that it's informational. We don't assume any liability for the content of that information.
I might point out, relative to the property address, while there is a spot in that transaction identification data for the property address, and it is within that bracketed area where, as you point out, Dan, we make clear we assume no liability with respect to any of that information. There are certain endorsements, we know, that do provide coverage relative to the accuracy of a property address. We don't actually insure the accuracy. We insure against loss or damage if the property address isn't as we say it is. A little bit of a distinction there, but later in Schedule A, if we have a separate line for a property address to which we can tick and tie for purposes of those sorts of endorsements, and the endorsements in question also have references to property addresses. And obviously, when used in that context, we certainly do intend to be assuming liability within the 4 corners of our contract. So I just wanted to make that point. And speaking of discriminatory covenants and how the industry has is trying to be responsible and responsive relative to them, you'll see a new introductory clause. Now, I think a lot of you may have become familiar with this kind of introductory clause as far back as 2016 and the 2016 ALTA commitment. The language has been changed to make clearer than we had before that if there are discriminatory covenants contained within instruments to which we take exception in Schedule B, we do not intend the discriminatory covenant itself to be the subject of our exception. So in other words, we are treating it as if it has been redacted, repudiated, removed, and not republished or recirculated. And then we make clear in the last sentence of that discriminatory covenants introductory clause, only the remaining provisions of the document are accepted from coverage. And here's our definition of discriminatory covenant. And Dan, to show how involvement of our customer groups can sometimes cause a little bit of delay in accomplishing our adoption and publication objectives, this language was actually the subject of some additional recent dialogue that we had with our friends at Fannie Mae, correct? And
That's right.
Thanks to you on a call that we were both a part of about 3 or so weeks ago now, maybe a month ago, we were able to resolve their concern by adding a couple of words to the definition of discriminatory covenants. Obviously, that defined term being used in the introductory clause. You want to touch on that?
Yeah, one of our primary constituents, Fannie Mae, had some concerns about the definition that we were using for discriminatory covenants in the version that was published for public comment. In a call, we discussed what those concerns were, and we settled on just tweaking the provision slightly to indicate that what we mean by discriminatory covenant is one that is unenforceable because under applicable law it illegally discriminates against particular classes of individuals. And so what you'll see on the slide here in terms of a discriminatory covenant definition is a little different than what is posted currently on the ALTA website, but this is what will be in the version of the policy when it is formally published in the next few days or next several days.
And it's important in the definition too to focus on the word illegally discriminates. We spent a lot of time on that, but we all know that there are kinds of covenants that might actually discriminate, but that are not illegal. And an example would be in age-restricted communities. So we wanted to be very careful that we were only intending to redact and treat as if it wasn't a part of the recorded instrument illegal discriminatory covenants. And so we made that point in our definition as well. Now we get into the preamble of Schedule B, and you'll see what's highlighted there. It's long been a custom and practice, not necessarily always followed, but very often followed whenever we're ensuring leasehold estates or easement interests. We know that the content of those granting documents will often contain conditions of one sort or another, or terms. And in ensuring in Schedule A leasehold estate or an easement interest, it's not our intention to insure against the obligation that the lessee has pursuant to the terms and conditions of the lease, or an easement grantee has pursuant to the terms and conditions of the easement. Generally, and this is probably more the case in the commercial context than in residential, where you'll run into this, but it's pretty common for Schedule B today in any case where we are insuring leasehold estates or easement interests to see Schedule B exceptions that accomplish what you now see highlighted in the preamble. That practice may well continue, but again, in the interest of efficiency, we've built in to the preamble this clause that references the terms and conditions of any lease or easement identified in Schedule A. And we do the same thing in the loan policy, but we do more in the loan policy preamble, and you see some brackets in the loan policy preamble. You want to explain that, Dan?
Well, yeah, the brackets here are to allow for the use or not the use of Schedule B Part 1 and Schedule B Part 2 in a loan policy. Generally speaking, Schedule B Part 1 are exceptions from coverage, and Schedule B Part 2 are matters that affect the title but are subordinate to the lien of the insured mortgage. not everywhere uses a part 2, and so it's bracketed to facilitate either or. You can either use the language that includes a part 1 and a part 2, or the top provision if all you have is our Schedule B exceptions. It's also important to point out that for those areas where a Schedule B Part 2 is used for a loan policy, we've substantially rewritten the preamble to Schedule B Part 2. Instead of referring to matters that affect the title, we now say that covered risk, the priority coverage, applies to the items that are listed in Part 2. But we have now also added the phrase subject to terms and conditions of any subordination agreement that's listed. Rarely do we see a subordination agreement that is a true unconditional subordination that subordinates a matter unequivocally to the insured mortgage. You frequently see subordination, non-disturbance, and attornment agreements. Those are clearly not unconditional. Other forms of subordination that are limited or conditioned in some way. This now accounts for that, and it allows us to itemize matters that are at least conditionally subordinated in Part 2 of Schedule B, along with a reference to the subordination agreement or provision that affects it.
Yeah, so the point there, Dan, is if it is a conditional subordination, and it turns out that one or more of the subordinator's conditions have not been met by the holder of the lien to which the subordinator has entered into the agreement, we don't intend coverage against that. And so we just want to make that clear as it pertains to conditions to subordination that so often appear in what otherwise purport to be subordination agreements. And the non-disturbance or the subordination, non-disturbance, and interment agreement, SNDAs, frequently used in commercial lease contexts, is a great example. Now we get to condition 8. This is the owner's policy version. There are similarities in the loan policy version. Of course, we'll talk about that in a minute, and then there's a few differences. There's a couple of very significant and very beneficial things we've done here. The first is in the preamble clause and the sentences that are highlighted, making crystal clear in our policy contract what a policy of title insurance is and what it isn't. And the whole point here is to make clear that this is a contract and that we intend our liability to be governed by the four corners of the contract and not overlay doctrines that we don't believe really have legitimate application to title insurance, such as abstractors' negligence causes of action. There are statutes enacted in about 9, 10, 11 states that effectively by statute say what we say in this highlighted portion now of the preamble. And yet not all states have those statutes. We continue to see challenges around the country in states that do not have those statutes, where plaintiffs will take a run at trying to impose a kind of tort liability on a title insurer under its title insurance contract that is really not intended. What I like to say to state land title associations in any state that does not have a statute like this, and I'll say it again now, don't not seriously consider working with your legislative body in an effort to try to get a statute enacted in your state. We think this is a positive step in our contract document, but I don't think in and of itself it should lull anyone into believing that a statutory fix isn't still a very valuable approach to this issue. And so I didn't get a chance to check on the states and the Southeast Land Title Association and whether or not they each have statutes like this. If they do, congratulations. I'm so delighted. If they don't, or if any of them don't, then take my suggestion and seriously consider trying to push such a statute through. However, until you do, or even when you do, we still think it's good to have this language in the policy contract. Then we've made a few other tweaks, and first in 8A Romanet 2, the clause that has historically spoken in terms of value of the title. This is our diminution in value measure of loss. We've clarified that we mean fair market value of the title. And then really importantly, in 8B and 8C, for the first time in our title insurance contracts, we've added to the contract specificity as to the date that applies as of which loss will be calculated. We've historically not had this in our policy contracts. Therefore, we have left it up to the judiciary to tell us what the appropriate date is. There is a majority rule among the case law around the country, and there are a few minority rules out there. We have adopted for both the owners and the loan policy the majority rule. In the owner's context, as you see in 8B, it's the fair market, it's calculated using the date the insured discovers the defect, lien, encumbrance, adverse claim, or other matter insured against. So that's the default rule. It's the majority rule. Your states may already have that as part of their case law. If you don't, if you have a different standard established in case law in your state, then this will mean there's a change. And it's a good change. It's good to have the contract provide for this. It's a wonder that it's taken us until now to have this in our contracts instead of relying solely on case law. But the case law in many jurisdictions is so well established that it's worked fine. It's really in the instances where case law hadn't previously spoken to it that we've gotten some decisions that were a little eye-opening and laid down some calculation dates that really weren't practical and really weren't intended. But we don't stop with 8B. We move on to 8C. And here we're dealing with types of claims, covered claims, where it turns out that the title was void, ab initio, you might say. Yes, thankfully, we avoided use of the word ab initio. We do try to use plain English as much as we can. As you read our 2021 policies, maybe reasonable minds will challenge us a little on that as to whether it was all as plain as we intended, but we work really hard on that. So in the case where it turns out that because of a covered defect, the title was never valid in the first place, well then we think it's fair that the insured should have an election. So here it's the insured's election whether to use, instead of the date of discovery of the defect, the date of policy. That the insured will obviously choose what the insured believes to be in its best interest. And generally speaking, here's where it will matter, I think, whether we are in an appreciating real estate value market or a depreciating real estate value market. We all know at the trough of the Great Recession, we saw real property values depreciate. Generally speaking, though, real property appreciates over time. So generally speaking, it is in the insured's interest to use the date of discovery, because the fair market value of the title or the diminution in value of the title should generally be greater at the date of discovery than it would have been at time of acquisition or date of policy. But in the limited instance where the basis of the claim is that the property owner never had title in the first place, then it's fair to allow as an option for the insured to select date of policy, and that is 8C. And then in 8D, we have what came into our policies for the first time in the 06 policies. This section is sometimes referred to as the cure penalty section. This is where the insurer exercises its rights to cure the defect, to try to place title into the condition insured, whether through litigation or otherwise, but is unable to do so. So we take the time to do it, we spend the money to do it, but it turns out we are not successful. Then in 8D1, the amount of insurance is increased. It's 10% in the 06 policies. We've gone to 15% in these policies, and then we've moved it, and then we've given the insured two other choices in 8D Romanet 2 for different dates as of which they can have the loss calculated. Gina, I see you're on camera.
Yes, I just wanted to remind you guys that you've got about 8 minutes left and you've got a fair amount to cover. So I wanted you to just kind of take that into account as you go forward.
We appreciate that so much. Dan, we want to go on to the loan policy version. Take this real quick.
Sure. Pretty much what Paul said applies to this. We have the same kind of disclaimer language in the introductory provision. We have introduced the concept of fair market value, the difference in value. In the loan policy context, the insured has the ability to have the loss is calculated either at the date of foreclosure or deed in lieu of foreclosure, or if the insured mortgage is extinguished by a covered matter, that would be the appropriate date of loss. We did not include the election of the lender if the loan is void ab initio, like we did in the owner policy context. We think the loan policy already provides adequate coverage, for covered risks based on the amount of insurance and just the way the loan policy works, and the same cure penalty in C. Being increased from 10% to 15%.
New condition 10, or I should say revised condition 10 of the loan policy is another really, really positive change we think should add clarity and cut out a good deal of litigation that's occurred over time in new condition 10B. There was positions sometimes taken in loan policy contexts where the lender bid in at the foreclosure a full credit bid, or even if it's less than a full credit bid, whatever it was they bid in to acquire the title through the foreclosure process was often deducted as if that resulted in a reduction in the amount of insurance. And so that's been an area where Lenders Council and some of the lender-oriented groups such as the American College of Mortgage Attorneys have long commented they feel it is a trap for the unwary and needs to be cleaned up. So we've done that in 10B, where we make it clear that whatever is credited at foreclosure does not reduce the amount of insurance. So it won't be a case where if it's a full credit bid, your amount of insurance goes to zero. Here we are in condition 15, and Dan, I'll let you take this.
Yeah, like we talked about with the Alta 47 endorsements, one of the important operative law changes that we made in the 2021 policies was to specify, utilizing our defined term state, which is the state or commonwealth within the exterior boundaries the land is located, or one of these specified districts, that the that the choice of law and the jurisdictional forum is the state, or where applicable, the federal law or federal courts to govern the interpretation and enforcement of the terms of the policy. We covered this pretty adequately in our discussion of the 47, but this is where, importantly, we built this into the 2021 policy forms.
We have a new condition in each of the loan and owners policies, making clear that class actions as to disputes or claims arising out of or relating to the policy or services or other matters in connection with issuing the policy are not allowed. So it's a contractual obviating of class action remedies in our policy contract. Something we think will help the industry. Arbitration has long been in our policies. There are some advanced changes here in the language, but the dollar threshold below which either the insured or the insurer can unilaterally trigger arbitration has remained at $2 million. You'll see brackets around this clause, again, meaning it's optional. So individual underwriters will make determinations when they go through their filing and regulatory process, whether they do or they don't want to have an arbitration provision contained in the policy. If they choose not to, then because it's the last numbered condition, it won't mess everybody up to see something deleted in the middle of the conditions section, as would be true of the 06 policies today. We also know there are some states that by regulation of insurers do not permit arbitration in insurance contracts. Obviously, these get deleted in those states. Otherwise, there you have it. Next, Dan. Let's talk about quickly all the other forms that are a part of our 2021 package, shall we?
Yeah, obviously, we have tried to address all of the commonly used forms. There's still a couple that we're working on. The mortgage modification policy, the junior residential loan policy are still in the works, but there is a updated version of the commitment along with an updated short form commitment. The short form residential loan policy, the homeowners policy, expanded coverage residential loan policy in both its forms, the current assessment and assessment priority, as well as the short form versions of that, have all been given the same kind of conforming updates to those policies. The homeowner policy has a variety of other changes to it that are beyond just making it align with the changes made to the base policies. So watch for, I imagine there'll be some educational programs available on the homeowners policy. I know it's commonly used in many of your states. So more to follow on that, but that is updated as part of the package as well. And then a number of endorsements have been modified for use with the 2021 policy. You'll see it's a fairly extensive list. Those endorsements, some were modified to conform to the changes made in the 2021 policy, typically the use of defined terms, but many of these were modified because of the McGirt issues, the native land issues, and so they have been modified to make it more explicit that they are to be interpreted or based on state or local municipal laws, as opposed to the possibility of the endorsement being interpreted under tribal law. And then you'll see one brand new endorsement. If you're familiar with the ALTA 34 identified risk endorsement, this is very similar to it. It's kind of given a more user-friendly update. I would say it's an alternative version that is a little more explicit in terms of completing the blanks, and we think might be better for use in certain circumstances. And that brings us to where we are now.
So Kelly, Steve, if you guys want to come back on camera for just a moment, would love to have you speak up at this point to this aspect, and then we'll bring it on to questions.
Sure. Steve, would you like to jump in on this one?
Go ahead, Kelly.
Okay, well, I think you all are probably very experienced out there in SLTA land, and you know how these things go. Watch your underwriter bulletins, watch your title production software updates as well. Pay attention to Alta News and Information. So if you get your title news online and your news you can use, notices will be provided there. You can always see what's new and what's the latest at the Alta website, and there's the URL, alta.org/policy-forms. And as Steve offered earlier in the presentation, if you'd like to be on the distribution list for direct news about the forms from Steve himself, just let us know and we can add you to the list.
Thanks. Anything to add real quick, Steve?
No, that's all. I think just so that everyone has my email address, it's sgold, G-O-L-D, @alta.org.
Thanks, Steve. So just last thing I'll say is you've heard it mentioned that we have an upcoming formal publication date. We're going to be deciding during our meeting this week what date that is going to be. Right now, we're looking toward August 1st. It could be pushed a little. So again, stay tuned for your news and notes. However, we're going to maintain the July 1st formal adoption date. So once these products become formally published, that's the point at which all the software vendors get the pleasure of doing what they do so valuable to the industry. We know they are already about the process. Steve's been receiving questions from some of those software vendors as they in turn have been getting questions from their customer groups. So that'll be a big part of what we're doing. We did have the board adopt, if you will, a formal decertification date for the 2006 policy forms, or the existing version of the other forms that Dan had mentioned in that list of a slide or so ago, of December 31st, 2022. So roughly speaking, 18 months out. The certification as a recognized ALTA product doesn't necessarily mean it won't be available from individual underwriters after that date. But what that tells you is we fully expect that this rollout process, before we have fully moved into the 2021 policy form world, is going to take at least 18 months. In some states around the country, perhaps a little bit longer than that. With that, I think we are at our questions point, Gina, and it's back to you. And I'm sorry for running long here.
Oh, no, that's fine. Kelly, did we have any questions?
Not a one. So I think everybody either got what they needed from the presentation or might be holding their questions to share with us later on. Obviously, we're all available for questions down the road if they arise.
Okay, we'll take care of that. And please don't hesitate. If you think of some later, we can get these to this group and get your answers. Before we leave you guys, I want to say thank you so much to each and every one of you for sharing your valuable time and extensive knowledge with us. This has been fantastic and we really appreciate it. So thank you so much. Jeremy, can you quickly come on so we can do the last door prizes? And then I'm going to make a last couple of announcements after that.
Absolutely. So we'll get right to the wheel so that we can get you on with your day. But again, thank you so much to all of our speakers. We appreciate you so much. So William Cruz will be our first winner for the $50 gift card from Republic National Title from the Alabama office with Gina Matthews. Gina, again, thank you so much for that. And we have another $50 card coming from WFG National Title Insurance. Again, that's with our friend Tamara Brooks in Georgia. And that will go to Jason Polson. Congratulations, Jason. Laura Morrison, congratulations. Can you guys even see that? I'm doing a horrible job. I'm sorry. Laura, you will be the winner of the $50 gift card from First American Title Insurance with our Alabama office, Jance Wojtnowski. Thank you for that, Jance. And then we have one gift card left, and this is from Old Republic National Title from our Mississippi office with Terry Wheel. And that one will go to Heather Hill. So congratulations to you, Heather. We will make sure to get that out to you. And then I actually have one final door prize. I'm going to move the camera back around. Sorry about that. Steve Gold, who is actually obviously with us today, has made a very generous donation. So thank you so much for that, Steve. We really appreciate you. So as we know, ALTA offers several legal publications, which is, a lot of research is used for that for land title professionals and claims counsel. And so 8 years ago, ALTA was working with Bush Nielsen, if you know him. He is a title industry attorney that's very well known. And so they were working and providing the title and escrow claims guide. So Steve has offered for a electronic membership, or excuse me, electronic subscription to that, which is a $200 value. So that will come over to you, and it's got all kind of, it's actually 1,744 pages of useful legal analysis and claims and information on there. So this is just a tremendous tool. If you do not want this, please forward that over to me. I will be more than happy to take that and use that tool. So thank you so much for that, Steve. I really appreciate your generous donation. And so the winner for that is, we're going to spin that wheel one more time. It didn't work. And that's going to go to James Muncie III. James, congratulations on winning my gift. I hope you enjoyed that. Again, Steve, thank you so much. That was really great of you. Thank you to all of those that donated today. We appreciate your support more than you know. We could not do what we do without you. And we thank you and hope to see you soon. Gina?
Thank you, Jeremy. You will receive an email later today, which will include a brief evaluation form as well as a form to complete, giving us your state bar number and/or your Alabama Department of Insurance license number. We need this filled out and returned to us quickly so we can submit your CLE and CE credits. And do not forget to put the 2 codes on the form for each section, because that is required. My last announcement is this. I want to say that when the pandemic hit, we had to cancel our mid-year. We had to postpone our convention in Charleston. And that was sad, but what the board really focused on is we realized it was more important than ever to keep our members informed and current. So we worked quickly and we worked fast and we worked hard, the board and the committee chairs and volunteers, to bring numerous e-learning events to you during this whole time. We also had our very first hybrid mid-year event in Birmingham in April. And these virtual title schools is a continuation of this effort on your behalf. And again, cannot thank this panel enough. And I'm very pleased to announce that we're going to have an in-person annual convention in Charleston, September 16th through 19th. And these virtual events leading up to that, as far as I'm concerned, we could not have a better precursor to that event. You guys and the other guys that have presented up to this point have just done a wonderful job of setting the table, and just we're going to continue it on into the convention. I'm pleased to announce that The speakers are set, the topics are there, and it's going to be a great e-learning opportunity for all of you. Look for a brochure, a flyer to come out later this week announcing all the good stuff about the convention. And I'm so excited and I look forward to it. And I hope to see you all there. I'm also going to say that this is one of the greatest benefits of these type of associations, ALTA, and in our case, SLTA, the sharing of information, knowing that we have each other to rely on, that we can keep each other current, that we have all of these resources. And this to me is just an incredible benefit to all of us. So if you're not a member of ALTA or SLTA, I invite you to join today. If you are a member, then I invite you to get more involved and help us take care of each other and take part in controlling your own destiny. So with that, I will say thank you for joining us and have a wonderful day. Goodbye.
Thanks all.